Good morning. You're Raul Carreno, and Mr. Carreno's case is set for trial to begin with jury selection next week. Mr. Matuska, Mr. Nichols did mention to me this morning an issue.
It's with scheduling. The DNA was sent out to a private lab, and they were requesting a little more like a month or so ahead of time notice, and I only gave them a few weeks, and they said they wouldn't be able to schedule.
Okay.
So I'm asking for a reset for that.
And that's a private, it's not the normal lab that we use?
It's not DPS, it's a private lab that was used to expedite testing in this case.
Okay. Obviously, we need that, I would think. Okay, so what I'm going to do is I'll reset it to the next trial docket. Obviously, at that point, it'll be time probably to get it done. That'll give you plenty of time to get with them now that we know that issue. And so we'll get that taken care of and get it on the next trial docket.
Yes,
okay, thank you. Go back with the bailiff.
Buckle up, guys. Today we are going to break this courtroom session into 6 tight, usable clips, each one focused, suspenseful, and under the 2 to 3 minute limit so you can drop them straight into your edit. Below each clip I give the exact start-end times, from the transcript you provided, and a sharp third-person commentary, 500 to 550 characters, that summarizes what happens and why it matters. Use the clips in sequence, intro first, then parts 2 to 6.
Is Mr. Samuel here? Odd Samuel?
I did see.
Oh, yes, I'll hold your case. And Mr. Wilkerson, it looks like you've got a tablet out. Are you working on paperwork on Mr. Johnson?
No, Your Honor.
Okay, Romeo Johnson. Morning.
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 The judge opens the docket, flags a DNA scheduling problem and resets the trial, a precise procedural hook that sets stakes for later. This intro clip captures the courtroom's tone, the scheduling tension, and the hint of forensic delay that will ripple through multiple cases. It's tight, informative, and gives viewers immediate context for what follows.
Good morning. Are you Romeo Johnson?
Yes, ma'am.
And this is cause numbers 24 DCCR 2095 and 2419. Mr. Johnson's cases are set for trial to begin with jury selection next Monday. What is the announcement?
We're ready, Your Honor.
All right. Anything that changed in negotiations that we need to go over today?
I was given some additional discovery materials, but it's just a complete autopsy.
Okay.
There's no new offer or anything for me to present to my
I'll entertain a counteroffer.
All right. If y'all want to visit this morning, just to double check if there's any counteroffer or anything like that, let me know. I'll hold it for a minute. Otherwise, it'll get numbered for trial.
Yes, Your Honor.
Okay. Thanks.
The session begins with a crisp procedural moment. The judge discovers outsourced DNA testing can't meet the trial timeline and orders a reset. That simple administrative snag is a narrative hook. It introduces delay, raises questions about evidence handling, and primes the audience for ensuing legal drama. This opening grounds the viewer in court rhythm and promises higher stakes moments ahead.
Mr. Galmore, you've got Ronnie Green.
Ronnie Green.
Good morning.
Good morning. Good. How are you?
Pretty good.
Let's see here. And this is for, you're requesting bonds on the 2 motion cases,
Yes.
correct?
He's on deferred on 2 different cases.
There's also additional fees.
Thank you. I'll pull that up now, Mr.
I'm just really asking for a setting on those additional files.
Okay. Oh, okay. Okay, good morning. Are you Ronnie Green the third? And Mr. Green, we have 23 DCCR 1502 and 24 DCCR 1320. Mr. Green is on probation for possession of a prohibited weapon and possession of marijuana. Motion to revoke probations have been filed in those two cases. There's a new indictment in cause number 25 DCCR 0735. Mr. Green is charged with money laundering. Mr. Galmore has filed writs asking that I set bonds in those two MTRP cases. He is on deferred probation, so generally entitled to a bond, but based on the nature of those offenses and that new offense, I wanted to have a hearing and get the state's input on their position on bond amounts, and bond conditions.
Your Honor, the state's filed a reply to the writ that was filed by Mr. Gilmore. I don't know if you had an opportunity to see that or review it. I've kind of laid out the state's argument
Okay,
in that reply.
let me look at it
I'm happy
real
to read
quick.
that.
I feel like I might have seen it, but I've slept since then, so give me a second to.
Judge, I don't know if you see letters in there as well. There's been letters that have been supplied to the court.
Okay, I'll take a look at all of that. I don't know. Do I have any of that over there? Anything printed out on him? Some of that sounded familiar. Yes, okay, so I saw the letters.
Yeah.
I can summarize it for you, Judge.
Okay, the letters I got printed. Let me look at this real quick. Now this is looking familiar as well. So yeah.
This segment introduces Romeo Johnson, arraignment details, trial scheduling, and the defense noting a full autopsy in discovery. Short, tense, and informative, it shows counsel preparing, the state's posture, and the candidate for trial sequencing.
And I recall now what you filed also with regard to some requests, and we'll get that set for the appropriate time, Mr. Coleman, as far as modifying bond conditions and things like that. And I guess you've seen those.
Absolutely.
I don't know if y'all want to talk about that, if there's some agreement or not. But for this morning, Mr. Galmore,
Romeo Johnson's matters are called, his trial set for next week, and counsel flags a complete autopsy just produced in discovery. That revelation escalates pressure. A fresh autopsy can change plea strategy or force continuances, turning a routine scheduling call into a real turning point. Observers see defense caution, the court's procedural posture, and the subtle pivot from administrative to evidentiary
I
state.
guess you can just make argument or...
Yes, Judge. I would just like to summarize a few things real quick. He is on probation for 2 cases. They are different offense dates, but I want to point out that he did not receive probation and then pick up a new case. These were the situation where he received probation and there was an older case that just simply not been filed yet. Since he's been on probation, there has not been the commission of any new offenses other than the offenses we're talking about today. I would say that he's been in jail for 20 days, which is longer than any other time that he's ever been arrested before. I did have discussions with the state today about a possible resolution that would involve Mr. Green going to ISF and not revoking his probation. And that sounds like a reasonable outcome. I have not had an opportunity to review the discovery in the new case, and so I don't feel like I'm in a position yet to advise my client on what would be the best option as far as that's concerned. I would point out that in the letters, there's one thing that really kind of struck a chord with me, is that since this alleged offense of the money laundering, which was earlier this year, Mr. Green has really taken a lot of efforts in his life to start walking the correct path. He became more involved in his church. He was baptized since the alleged commission of this offense. He's got a lot of family support. His mother is here in court today on his behalf. And so what we're just simply asking the court to do is set reasonable bonds. He is on deferred. And even though there is a new offense, I would say that the majority of all motions to revoke probations are based on illegal activity. Even if it's not a new offense that was committed, it's alleged. Very common is a failed drug test, and obviously if you're failing a drug test, you're committing a crime at some point, possessing that illegal drug.
The hearing shifts to Ronnie Green III. Probation status, new indictment for money laundering, letters from supporters, and bond arguments. Defense emphasizes rehabilitation. Prosecutor stresses serious allegations. This is a humanizing, dramatic exchange.
So we're just simply asking the court to set reasonable bonds. I believe reasonable bonds in this scenario would be about $10,000 on each case. I believe the government is asking for $50,000 in their motion.
Your Honor, and Mr. Galmer and I agreed that we were both asking the court to set reasonable bonds. My version of what's reasonable, given the fact that less than 1 year since the defendant was placed on 2 deferred adjudications, he's out allegedly committing money laundering. If the allegations are proven true that money laundering, those proceeds constitute proceeds from drug trafficking or delivering controlled substances, Judge, the opportunity, as Mr. Galmo put it, to walk the right path, the correct path, came back in 2024 when this court put him on probation for possessing a weapon that was outfitted with a Glock switch. My version of what a reasonable bond should be in light of this defendant's actions is no less than $50,000 in each case.
So if there is well, 2 things with regard to what you're talking about. One is, depending on whether or not the allegations were proven true, and if there was some thought of continuing Mr. Green on his probations and getting a probation on that new case, the only way I would go along with something like that would be for ISF, some type of cognitive program in custody. And while I understand and appreciate that he's making some strides on his own, from a legal standpoint,
Ronnie Green's hearing juxtaposes personal turnaround with severe new allegations. Defense counsel highlights church involvement, baptism, and family support. The prosecution stresses the gravity of money laundering claims and public safety. The judge's careful review of letters and filings creates suspense. Will compassion or risk assessment dominate? This part humanizes the defendant while showing the legal system weighing competing narratives.